Parliament Hill. Its strength is really from the source of collaboration we've had from different partners from across the country. And I wanted to take an opportunity today to say thank you. Thank you to the premiers and provincial justice ministers who have helped inform this bill. Thank you to the municipal councillors and mayors who have reached out with their perspective. And thank you, most of all, to the law enforcement officials who have informed the measures that found their way into the text of this bill. It has been a tough couple of weeks to be a police officer in this country. We've obviously seen 2 deaths in Ontario, more recently a potentially fatal accident that has caused a serious injury for an officer. My best friend growing up is a member of the RCMP. If you have an opportunity to speak to a police officer today, tell them thank you. Thank you for the work that they do to put themselves at risk to keep the rest of us safe. When I think about the spirit of collaboration that we took when it comes to this bill, I want you to know it's not just idle words meant to fill time at a press conference, but very specific measures that we can trace back to the conversations that we've had. I received a text this morning from the Mayor of Winnipeg, Scott Gillingham, thanking the government for its adoption of the bill. Scott, if you're watching, I want to thank you in return. Ben, I believe, is here from Winnipeg, are a big part of the reason that we saw retail crime included, high-volume offenders who continue to place into jeopardy the well-being of our downtowns. I think about the engagement I've had with provincial governments, Nikki Sharma in BC, uniquely responsible for the changes that deal with bail after a person's been convicted before they've been sentenced. I think about the work of Justice Minister in Alberta, Mickey Amory, who was the first to raise with me the need to address crimes against essential infrastructure, including copper theft. I think about the extensive engagement with my Ontario counterpart, Doug Downey, who has spent an ungodly number of hours on the phone with me, working with his department, his team working with mine, to ensure not only broad subject matters of interest were captured in the bill, but that the provisions included were designed in a way that would meet the very real challenges that people are facing in Ontario. Of course, the government's public safety strategy rests on 3 pillars that we've been talking about since the time of the last election. The first is to strengthen Canada's criminal laws, and with the adoption last night and royal assent of the Bail and Sentencing Reform Act, we've taken a major step forward. But we also know that there's more work to do. We expect by the end of the week we could see the Combating Hate Act, which is being debated in Parliament behind me at this very moment, and the Protecting Victims Act, which is at the final stages of the Senate to potentially become law. In addition to those new laws that will strengthen Canada's criminal code, we're also doing more to support those on the front line. Sometimes that means putting new legislative tools in the hands of law enforcement so they can keep pace with changing practices of criminals to ensure that they can combat crime and promote public safety in the modern age. But it also includes supporting organizations on the ground, including women's organizations that support women and children who are fleeing violence that need access to certain social services in order to help rebuild their lives or to be receiving the care that they so desperately need. But if we want to end violent crime in the long term, we know that we're going to need to make upstream investments in things like affordable and transitional housing, in mental health and addictions, and programs that target at-risk youth to ensure that we build healthier communities and stronger people who are less likely to fall into a violent life over the course of the next number of decades in this country. Despite the fact that we know that work remains, let me not diminish what an important step forward Parliament has taken last night. The Bail and Sentencing Reform Act responds to what was, at the time of my appointment to this position, the most pressing policy and political issue, whether I was talking to mayors, whether I was talking to provincial governments, or whether I was talking to law enforcement. To those who've taken time out of your days, out of your months, out of your year to help inform this work, know that I'm grateful for your support along the way. My hope is that the spirit of collaboration that we've seen in the development of this bill can continue through its implementation. In that regard, we're starting with direct financial support to provincial governments to help better collect data in a standardized way when it comes to bail systems in this country, so we can actually measure the impact of the changes that we're making in this law to inform future changes to Canada's criminal code. By continuing the spirit of collaboration, we're going to be able to build a safer country. We've taken a major step forward last night, and the reason we were able to do it is because we've done it together. Thank you very much. I'm happy to take your questions.
Can I ask you just a couple of questions about the 2 issues to make this go forward? Our prisons are overflowing, often with people on remand, and there's just not enough judges in this system. Judges is you, I think. You got to appoint judges in most cases. And what about the provinces and their ability to provide more resources to house prisoners?
Juste avant de répondre à vos questions, il est essentiel pour moi de décrire les mêmes choses en français, mais très bref. Hier soir, c'est une bonne chose. Notre Parlement a adopté en C14. C'est un projet de loi très important pour protéger nos communautés. Un grand merci de mes homologues pour tout notre pays et pour les policiers qui luttaient contre les crimes dans les communautés canadiens. Avec les provinces et territoires, avec les cités, avec les policiers, nous créerons une nouvelle loi pour protéger les communautés. Mais après le moment, la loi est adoptée, nous continuons de travailler ensemble pour protéger nos communautés, pour soutenir les personnes qui travaillent sur le terrain et en même temps faire des investissements pour lutter contre les crimes dans le long terme. Merci en particulier de mon homologue au Québec, Simon Jolin Barrette, pour nos conversations sur ce projet de loi et des autres aussi. Nous continuons de travailler ensemble pour protéger nos communautés. Thank you, David. Sorry for the delay. It's important. Sorry, the second part of your question was judges. Remind me of the
yes,
first part.
We got a lot of vacancies of judges, but prison systems. We've seen Ontario, they need to build more jails. Everybody needs to build more jails, apparently. You heard testimony at committees. Jails are overflowing. How do you help provinces with that problem?
So there's several things that we need to do. Maybe I'll address the issue on judges first and come back to you on the capacity of provincial systems to deal with the rate of incarceration. On judges, thankfully, we've made significant strides. Today, there's approximately 24 vacancies nationally, which historically is a healthy number. We expect in the next number of weeks to reduce that number further and are making appointments at a pace that gives me confidence we can more than keep pace with retirements that we see on the bench. In addition to the conversation about filling the vacancies that we have, I'm engaged in conversations with provincial counterparts and taking submissions from courts and provinces on potential increases to the judicial complement. As those requests come in, based on the business cases that are shared with the federal government, we're able to assess with a greater degree of certainty where we can have the biggest impact, and if the number of judges requested in a given jurisdiction mirror the caseload that they are in fact dealing with. That's an annual process that's playing out in real time, and as we have information that we receive from different jurisdictions, we'll potentially be able to look at increases, but not before we rigorously assess the business case. On the issue that you mentioned, I would be careful not to paint all provinces and territories with a single brush, because they're in unique sets of circumstances that don't necessarily reflect the experience of one province in a neighboring province. This is a reflection of the fact, as I'm sure you're well aware, that provinces have jurisdictional responsibility for the administration of justice. We deal with the criminal code. They deal with the implementation of the rules contained therein. There are some things we can do that will help diminish the volume in the courts, which will help the processing in the court system with procedural changes to the rules that are in place. But when it comes to incarceration, that is a decision that provincial governments are going to have to make. But keep in mind, the goal with these strengthened reforms in the short term, certainly, is to address very real challenges when it comes to public safety, the rate of crime that we've seen that we hope to take down, and are seeing some positive trends in that direction, by the way. But the long-term vision is not to incarcerate more people. It's to prevent crime from happening that demands incarceration in the first place. By ensuring that we focus not only on the short-term measures around bail and sentencing, but building healthier people and communities by investing in affordable and supportive housing, by investing in mental health and addictions, by investing in diversion programs targeting at-risk youth in particular, and at risk of stretching things a little further, building the kind of infrastructure that creates healthier communities. We believe that we can reduce the rate of crime in the long term. In the short term, we still have to deal with certain challenges. Where there are provinces who are asking for these changes, by the way, who have provincial systems that are already at capacity, those provinces may be required to take decisions to increase the capacity. I will leave it to provincial governments because the answer in Ontario may be different than Nova Scotia, may be different than Yukon. But the very bodies that are demanding these changes are often the ones who have responsibility for the management of the system on the back end. I should say with without exception, provinces are acutely aware of these challenges and want to deal with them. They are demanding the changes that we put in place, and I fully expect that they would be prepared to inject additional resources where appropriate in order to meet the demands that any changes to the criminal code may foist upon provincial systems.
On OpenAI, you said all options are on the table. Does that include suing OpenAI over their AI security risks?
Look, it's outside of the scope of my certainly my announcement today, but my portfolio. When we look at the outset of a given file, we always start with the wide end of the funnel. We typically want to, in a given set of circumstances, understand what are the range of outcomes that we may be seeking to look for, and we start with a very broad consideration of potential options. So when we say all options are on the table at the beginning of these conversations, we mean it. Through the process of identifying the path towards the solutions that we hope to adopt, those options become narrower. But I'll leave it to my colleagues for any future announcements as it may impact an individual player in the AI sphere.
Okay, assurances, though, I know you're saying it's going to be up to the provinces to make those investments, but I know that your predecessor said when this debate first emerged that we don't have even provincial statistics on terms of what's driving people getting out on bail. Like, are you confident that they're actually going to hold up their end of the bargain? And if so, what reassurances can you offer Canadians that you're actually going to see those investments happen on the provincial level?
Sorry, that's not an alarm for us, is it? Yeah, okay. Yeah, you and me both. You and me both. So there's a couple elements to your question. There is a paucity of data when it comes to the criminal justice system and to the bail system in particular in Canada. And in addition to the challenges that we see on a national scale, where there is data, it's not necessarily collected consistently as between jurisdictions, and the sharing of the information that currently is collected typically by provincial governments as the custodian of this information. We don't necessarily have the best practices in place to share that data, despite the fact that we know very well offenders may cross borders, ironically, more readily than data is being shared across those same provincial boundaries. In addition to discussing with and working with provinces to identify where these gaps exist, we're putting money on the table. We're starting with a short-term investment that's going to provide a few $1 million nationally to collectively to each province to standardize the practice of data collection when it comes to the bail system, and importantly, have that information accessible to other provinces and to the federal government, so we can actually measure with a higher degree of rigor the impact of the measures that we're putting in place today. Despite the fact that there hasn't been perfect data over the last number of years, we can also rely upon the lived experience of Canadians who are reaching out to the federal government, of provincial premiers and justice ministers who have legal responsibilities to their constituents and to the systems that they administer, as well as the reality that law enforcement experiences, particularly when it comes to violent and repeat offenders. There are some bright spots across the country that do a better job, typically at a municipal level, of collecting data when it comes to the criminal justice system, but it's not done in a uniform way and shared as wisely as it should be. With the support that we're putting in place, we will position provinces and territories better than they are positioned today in order to collect and share this data, so we can learn lessons for policy changes, not just at the federal level, but potentially at provincial levels as well. But just a final point on this piece. Provincial governments were some of the first demanding the federal government make these changes. During the conversations that I had with them, including at our meeting of federal and provincial ministers in Kananaskis last year, they know that there's going to be an obligation on provincial governments to run provincial systems, but they're still asking us to make these changes because they believe it's going to promote public safety. There may be a cost, but there's a unique appreciation which each and every one of my counterparts that cost is well worth it, given the public safety outcomes they hope to achieve.
Well, you mentioned that you, as you know, last October, last fall, almost every single trial court in Canada had asked for an increase in the complements. That didn't happen in the last budget. Now that you said that you're reevaluating those needs, and I'm assuming those requests remain the same at the trial court level especially, are you going into it with a new perspective? Are you more open to increases in judicial complements this year than last fall?
So I wouldn't assume that identical requests will be submitted. Some may have higher numbers, some may have lower numbers. We're going to assess them on a case-by-case basis. One nuance that I'd like to insert into this conversation is that the experience over the last number of years, particularly coming out of the pandemic, for different provincial systems when they looked at the federally appointed judges at the superior courts, was that we had too many vacancies for a few years. A huge credit to one of my predecessors, Arif Irani, who dramatically increased the rate of appointments, which we've been able to maintain. The reality that was facing provincial systems in some instances was due not to a complement of justices that was too low, but the de facto number of judges who were working given the vacancies that existed. With more and more of those vacancies being filled, we have a better sense of what the true baseline is going to look like in provinces across the Federation. With that new baseline in mind, we expect provincial systems, superior courts and provincial governments to update based on the reality that they're living with today, and on a case-by-case basis we'll make that assessment and determine at the next budget the level of funding we're going to make available to potentially increase the complement.
La police de Montréal est sous enquête pour des actes racistes. Montreal Police civil officers are under investigation for collecting trophy pieces of hair from suspects, which is seen as a racist act, and they're under investigation for that. Do you think this is a demonstration of systemic racism?
J'ai lu les articles ce matin sur cet enjeu, mais je n'ai pas beaucoup de détails. Mais si le détail est vrai, c'est un dommage. Ce n'est pas possible pour accepter le racisme si la personne a collecté des trucs comme ça. We have to be very mindful that as we try to strengthen the justice system, we strengthen it in a way that works for everybody. For too long, marginalized communities have faced disproportionate treatment by the justice system. Sometimes the nature of those differential treatments are systemic, tied to social and economic factors that we need to work to cure. There are other instances of blatant racism. Without passing judgment on the specifics of a scenario which I've read a news article about but haven't confirmed, I want to hesitate before I use such a serious label against any individual. But I think communities who have long faced discrimination are right to ask questions and to speak up when we see details like this emerge. I'll be taking an opportunity, hopefully later today and through tomorrow, to better understand the facts on the ground, to make an assessment as to the appropriate role for the federal government, of course in collaboration with my colleague, the Public Safety Minister.
So Toronto Police are searching for a 19-year-old suspect in connection with the U.S. consulate shooting and numerous other shootings in the GTA. They had a press conference this morning. And at that press conference this morning, they said they're distributing a photo of the suspect from when he was 17. He's now 19, he's an adult. But they say the judicial authorization for this photo of when he's 17 will expire on Friday. They can apply for an extension, but how helpful is it for public safety that police have to, even when they're using, when the suspect is now an adult, and they're using an old photo of him, that they have to do all this work to get his image out there for the public?
So look, thank you. I think there are some unique nuances that play out in the real world that don't necessarily reflect the intent of the rules that were put in place. And other times we have rules in place that are designed to, for good reason, protect the identity of youth offenders. In this instance, we're dealing with an adult who is alleged to have killed a police officer. We need to make sure that the police have the ability to do everything they can, not only to protect themselves, but to protect the public against a very dangerous offender. In this regard, we are making certain legislative changes that will make it easier, particularly in emergency situations that pose a danger to the public, for people to more readily disclose the identity of a person who may pose such a danger. We need to do what we can to protect the privacy interests of individuals and public safety outcomes. And sometimes procedures like this may reflect the rules that exist today, but in the present instance, legislative changes that are not yet in place won't help on a 48-hour turnaround, but my hope is that the courts will be ready to respond.
I read the changes. They wouldn't apply to this situation as I read them. They allow the police to publish an image when there's an imminent threat from a youth offender who is on the loose. But it doesn't do anything. This suspect is an adult, and the photo is from when they're 17. The legislation doesn't change any of that, change the rules around that. Is that something that you'd be open to changing? Does that issue concern you?
So I would first need to understand that there's a unique nuance in an issue that I've not delved into. This is the first time factually that I've learned of a case where effectively a youth offender has aged out of the youth status, where the only pictures that law enforcement would have were taken from a different time. There would be a question I would have as to whether that would still legally be considered a picture of a youth offender, or whether indeed that is now a picture of an adult offender. That's a piece of legal work and policy analysis that we've not done, having not been made aware of that circumstance playing out. Should we in fact need to look at legislative options to cure defects where we do have an adult offender who's potentially committed such a heinous crime, it would be something that I would be open to, but I would reserve the opportunity to do the policy work first.
Minister, where are you at on MAID, and are you willing to accept whatever the committee that's studying MAID recommends? Are you willing to accept whatever they recommend and put that forward?
Look, I'm never going to accept something before I've had an opportunity to review it for myself. I do expect in the very near term we're going to have a report tabled from the committee. I want to give them the space to complete the exercise to table the report. I will be reviewing the recommendations, but importantly to me, I'm also going to be reviewing the witness testimony upon which those recommendations were based. If I'm satisfied that the committee has had an opportunity to reach thoughtful conclusions based on the advice of those who are most experienced, most knowledgeable with the issues, then there's a good chance we may align with the recommendations. But having not yet had an opportunity to review the report that I expect will be tabled in a matter of days, I would refrain from passing judgment on its contents.
Can I also ask you, just as someone who oversees the justice system, Correctional Services Canada is looking at the use of artificial intelligence to help with developing criminal profile reports for offenders coming into the system. We've heard various concerns from people in the system about potential errors, hallucinations, or biases that might be exacerbated by that. They're just considering it at this point. Are you concerned at all about that type of use in the criminal justice system of artificial intelligence?
So I've got a very vague familiarity on the very specific issue that you've raised, again, falling into the purview of my colleagues in public safety. But I think it touches on a broader issue of social concern. And I think we need to recognize that AI is rapidly changing the world in which we live. With such rapid change, there will be challenges we need to protect against and opportunities that we must avail ourselves of if we want to deliver higher quality of governance and quality of life for Canadians. We need to be very careful not to cheerlead for the technology or be afraid to embrace the opportunities it creates. In the present instance, the right path forward will involve careful steps where we use new tools to ensure that we can deal with backlogs in systems, to ensure that we're reducing the reliance on taxpayers' money to deliver services to Canadians. But at the same time, we need to have guardrails in place that give different communities across Canada confidence that their privacy interests won't be violated, that they won't be discriminated against on the basis of the community from which they come. This is an interesting time filled with rapid technological developments, and it's easy to become excited about those opportunities. But every time we take a step forward to embrace the technology, we need to take 2 steps forward to give confidence to Canadians. Our ability to move forward will be limited to the speed of trust, and we're going to do everything we can to make sure we put measures in place so Canadians can trust the technology we use.
Does this specific example, though, concern you, given all the effort that you're trying to make to speed up the system? If errors are made, someone could have their case thrown out, things like that. Does it concern you, this specific example?
So, look, yes and no, and I apologize for giving an answer on both sides. It concerns me in the same way that I'm concerned generally about how we embrace AI as a government and as a society. But make no mistake, the world is changing, whether we like it or not. It's up to us not to choose some future where technology runs everything, or to go to some time in the past in a manner that we remember that likely never existed quite that way. The option we have is how to manage the change that's taking place. When I see an opportunity like this, being responsible for administering systems in government, I see huge opportunities to improve the quality of services that the Government of Canada can deliver, but I'm not blind to the very real challenges that you've raised. So in all instances, including the example that you cited, we need to accept that AI is going to be part of the future, but we need to move forward at a pace that gives us confidence we can protect against the social harms you've identified.
Regarding MAID, the committee was mandated to report back to Parliament by October 1st. The Liberal co-chair has been really clear that there was pressure to get it done quickly, that they wanted to have this back before Parliament, before it rose for the summer. Where's that coming from? Why do you want this on your desk sooner than October?
I'm not aware of what pressure was applied. I've deliberately had very limited engagement with any members of the committee. It was obviously, there was a decision taken to establish that committee before I found myself in this particular position. I watched with interest some of the deliberations of the committee, but very purposefully have not been trying to engage and certainly have not sought to apply pressure. So I'm not familiar with the source of such pressure and have not seen that comment.
Why the Liberals want this back so that you can draft some kind of legislation? Like, I'm just trying to understand, are you working toward legislation before March?
Well, look, I don't want to prejudge what recommendations we see from the committee. To the extent that legislation may be required on policy decisions the government will take but has not yet taken, legislation is one potential item that we could be working on, but that decision has not been taken very deliberately because we wanted to allow space for the committee to do its work. One thing that I will note, this is not specific to the issue that you raised, but cultural to the current government. The Prime Minister is expecting us to move. When we have an opportunity to have a positive impact to the decisions that we take, there is very limited patience to let something sit for several months if we have an opportunity to deal with a pressing social issue today. When we see work of the committee, which is largely complete, though not formally tabled, I expect we have an opportunity to consider thoughtfully their recommendations and move more quickly than perhaps governments of the past would. But this is not unique to this particular issue. I am feeling it from the Prime Minister in every area in which I hold responsibility. He wants action, and he'd like it yesterday.
Can you just talk in general terms about the changes you're making to the youth justice system and what you heard from stakeholders during consultations about where they thought this system was falling short?
There's not... people who have a perspective on this issue are not monolithic in nature. There is an enormous variety of views, and to the extent members of parliamentary committees concerned with youth criminal justice have an interest in doing a deeper study, I actually think it is an area where one may be warranted. We're seeing calls for action that would treat all youth as adults for certain serious crimes. We are seeing on the other side of the political spectrum, many people suggest in no circumstances should we embrace more serious penalties or incarceration. There are more nuanced debates playing out about what kind of crime ought to be treated as violent, which would potentially lead to incarceration for a youth offender. There's other changes that I referred to during a related question earlier around what circumstances it would be possible to disclose the identity of a youth offender to protect the public interest. What I see in conversations, not with provincial governments and police officers, but with ordinary Canadians who express concern, is real conflict where people have concerns about public safety, but also recognize, particularly with youth offenders, that when a person's incarcerated, they're almost certainly going to be released one day. And the general pattern that we see is when a young person spends time in incarceration, they tend not to become a healthier and more productive member of society by the time that they're released. So trying to square the circle that would allow us to demonstrate to the public we can offer protection in the short term, while at the same time focusing on long-term public safety outcomes is an extremely difficult task. There's certain very specific policy changes we've made dealing with emergency situations, dealing with a broadening the scope of what would be considered bodily harm to scope in more violent crimes that could lead to incarceration, while at the same time trying to promote diversion programs and restorative justice where appropriate. These kinds of instances are so inherently factual in nature. You may be able to build a rule, but how that rule applies in a given set of facts will be entirely dependent on the individual offender, the nature of the crime committed. But to answer your question about what we heard, every perspective on both sides of the equation on every aspect of the issue. Merci tout le monde, c'est un plaisir.
Thank you.